In this clip, we'll cover certain information and documentation that the parties to a federal civil case must proactively disclose to each other. We'll call these things mandatory pretrial disclosures. There are three broad categories of mandatory pretrial disclosures that we'll cover in this clip. Before we cover any of these categories, though, we need to discuss Rules 16 and 26F very briefly. After that, we'll talk about the first category of mandatory pretrial disclosures, namely the initial disclosures under Rule 26A1. Next, we'll cover expert disclosures under Rule 26A2. And lastly, we'll cover witness and exhibit disclosures under Rule 26A3. Rule 16A enables the court to order a pretrial conference. A pretrial conference usually involves the parties' attorneys coming before the judge in open court, where they will generally talk with the judge about the status of the case and identify any issues that need to be dealt with. Based on the parties' representations and the judge's own assessment of the progress of the case, the judge may adjourn the pretrial conference, or per Rule 16b(1), the judge may issue a scheduling order after consulting with the parties. Rule 16b(2) imposes a deadline for issuing the scheduling order, which isn't really relevant for our purposes here. Under Rule 16b(3), the scheduling order may accomplish any number of things that the judge deems necessary for the expeditious prosecution of the case. Among these is setting a deadline for completing all discovery and motion practice, as well as imposing a firm trial date. The scheduling order may only be modified with the judge's consent for good cause.